Good afternoon, everybody, and welcome to the McGuire-Woods presentation on weed in the workplace. My name is Kate Hardy. I'm a partner in the McGuire-Woods Charlotte and DC offices. I'm in the healthcare group, and I lead the McGuire-Woods cannabis practice. And we've got a lot of things to cover today, and we're really excited to be presenting this information to you. A couple of quick housekeeping notes for everybody. CLE credit applications will be made on has represented in court and provided strategic advice to several cannabis operators in Virginia's medical cannabis licensing program. And finally, John Thomas, who's an attorney in our Labor and Employment Department in Tysons, Virginia. His practice focuses on all management side employment issues, including non-competes, trade secrets, discrimination, and wage and hour issues. John has also provided a great deal of advice to employers on compliant drug testing policies and complying with federal, state, and local cannabis-related employment matters. All right, and today we are going to cover broadly recent developments in the law, employment issues. We're going to briefly cover banking and financial issues. We're going to talk about insurance considerations, and we're going to talk about federal reform. And with that, I'm going to get right into it. And Stan, I will turn it over to you to talk about recent developments in the law.
Great. Thanks so much, Kate. And thanks very much also to all of the attendees for joining us. This is going to be an interesting and exciting time as the Commonwealth moves forward with this process. So we're thrilled that you were willing to take the time to spend with us today. My job today is to get us up to the starting line, if you will. So I'll run through some of the key legislative steps that kind of got us to this point of having cannabis legal as of July 1st in just a few short weeks. I was interested to learn as I was preparing, Virginia was actually one of the first states to pass legislation that even acknowledged the potential medical benefit of cannabis, and that was back in 1979. A bill was passed that ostensibly allowed for prescription of cannabis for the treatment of glaucoma or chemotherapy side effects. Nothing happened with the legislation, of course, because of federal prohibition, but in the same way that we are the first southern state to allow recreational use, we were one of the first states in the union to acknowledge potential medical use. Fast forward to the 2000s. In 2015, legislation was passed that created an affirmative defense against possession charges for cannabidiol oil, more commonly known as CBD, or THCA oil. That legislative willingness to look at CBD and THCA as sort of the least offensive, if you will, of the many chemical compounds in cannabis actually carried forward to the more recent legislation as well. In December 2017, the legislature transferred regulatory authority to the Virginia State Board of Pharmacy, which started a process by which I believe over 51 or 52 different operators applied for 5 medical licenses in the state. In September 2018, after plowing through those licenses, which I'll note were put in at great expense to the applicants, in 2018, the Board of Pharmacy approved 5 companies to open vertically integrated medical cannabis operations in the Commonwealth. The first dispensary opened actually just in October of 2020. And I'll note that one of those 5 companies is currently tied up with litigation with the Board of Pharmacy, so they never got off the ground or haven't gotten off the ground yet, but the other 4 have. Things started to really pick up in 2020. In April of last year, Virginia decriminalized possession of up to an ounce of cannabis effective July 1, 2020. And then in the first part of this year, the movement really accelerated. So in February 2021, Virginia passed legislation to fully legalize recreational use and retail sales, which was a big step, to commence on January 1, 2024. Then, somewhat to my surprise, but to the surprise of some observers in the industry, the legislature actually approved in April of this year certain amendments recommended by the governor to accelerate sort of key events in the legislation. First, legalization was initially supposed to be 2024. Now, as I mentioned, it's July 1, 2021, days away. This new law will allow, as of July 1st, adults 21 and over to possess 1 ounce of cannabis, just walking around town. And households will be able to cultivate up to 4 plants per household without any penalty at all. I note in the slides that gifting of cannabis among adults is also permitted, and I note that specifically because some of you may be aware of the sort of gray market in Washington, D.C., where you can go buy ostensibly purchase a pair of socks for $50, and with the socks you get free cannabis. Virginia was well aware of what our neighboring jurisdiction was allowing up there and legislated around it. So we will not have that sort of gray market here in the Commonwealth. In terms of penalties, possessing more than an ounce and less than a pound will be a $25 civil fine. Possessing any amount over a pound can lead to felony charges up to 10 years in prison and significant fines. The legislation also automatically seals or expunges certain misdemeanor convictions and created a process that hasn't been built yet, but at least allows for a petition-based process that will permit folks convicted of more serious crimes to seek expungement. I gather there are some sort of data issues and legislative issues and agency actions that need to take place before that gets up and running. The law also prohibits use of cannabis in public spaces, in vehicles, and maintains punishments for impaired driving. On that note, and it'll be interesting to see how this shapes up, there's an open container law that assumes a person has used cannabis if they have a quote-unquote open container in their vehicle. And as it stands, open container is defined as a packaging from a duly licensed dispensary. So any folks who are carrying cannabis around from a now legal home grow or a legal gift are doing so at their peril. That will change when there are recreational dispensaries, but the next few years will be complicated on that front. The timeline for recreational sales stayed the same, so that will be 2024. There is a lot of work left to do on this. The General Assembly commissioned recommendations, which I believe were issued in the 4th quarter of last year from Virginia's Joint Legislative Audit and Review Commission, or JLARC. JLARC produced, extensive and, in my view, very thoughtful and thorough work product going through all the various factors the Commonwealth will have to consider as this potentially massive industry is built out. There are licensure issues. The big question is whether to independently license each step in the process, from production to testing to distribution and so on. There's also discussions about the role the government may play in that. There's been some consideration of having Virginia's ABC, which handles liquor, of course, but maybe having them fill the same role, or having an analogous entity fill the same role with regard to distribution and retail sales. So we'll have to see how that goes. There are discussions about allowing localities to opt out. So if a particular county or city just doesn't want a dispensary, I suspect the Commonwealth will permit that. There are also a number of steps that need to be taken to address disproportionality in cannabis enforcement. As folks on this call may know, Black Virginians tend to be arrested at a rate of roughly 3.5 times higher than white Virginians, and convicted at a rate of roughly 4 times higher than white Virginians, despite reporting similar uses of cannabis. So for folks looking for more information, I commend to everyone on the webinar JLARC's work product. They have a lot of written work product decks and white papers from the 4th quarter, but I'll specifically point out just this past Monday, June 7th, JLARC issued almost line by line, going through the entire bill, or legislation rather, all of the various things that still need work, some of the things that are kind of set and done, but almost quite literally line by line, places where more legislative action or more agency action are required. You can find that by just Googling JLARC June 7th cannabis. That'll probably bring it right up. The National Organization for the Reform of Marijuana Laws has a Virginia chapter. They have a lot of information as well, focused, of course, on the legalization activist perspective. And I gather that Richmond actually now has a nascent chapter of NORML as well. And for those interested in what will be the very busy business side of things, there are a number of publications. Cannabis Business Times is just one of many, but there's a lot of information available, and particularly after the licensing structure is set up and we head into January 1st, 2024, there'll be a lot of activity to look out for on the business side. So I thank you all again for taking the time, and I will hand it over to my colleague, John.
Thank you, Stan, and hi, everyone. This is John Thomas. As Kate mentioned, I'm an attorney in McGuire-Woods Labor and Employment Department. I'm in Tysons, Virginia, and my practice focuses on all management side employment issues, particularly issues involving non-competes and trade secrets, retaliation issues, and wage and hour issues. My involvement with the firm's cannabis, hemp, and CBD practice involves advising employers on compliant drug testing policies and remaining compliant really with all federal, state, and local cannabis-related employment laws, which is what we'll be talking about over the next few minutes. So let's get started. As Stan mentioned, the road that Virginia has taken is really quite remarkable. I know 10 years ago, we said kind of only half cynically that Virginia would probably be the last state in the union to legalize marijuana, and yet here we are. The progression in Virginia's marijuana laws since 2015 has affected not only the criminal penalties related to marijuana that Stan talked about, but it's also affected how employers must address the issue in the workplace. So I think most employers are familiar with accommodating employees who have disabilities under the Americans with Disabilities Act or other similar state laws. And the big question that employers in Virginia are facing right now is what happens when a Virginia employee has glaucoma or epilepsy or a pain-related medical condition or some other disability, and they request an accommodation to use marijuana? Is the employer required by law to accommodate the use of medical marijuana? And the short answer right now is that we don't quite yet know for sure, and let me explain why that is. First, we can broadly categorize how other states have responded to this issue. About, I would say, roughly half of the states that have addressed this issue expressly say in the law itself whether employers have a duty to accommodate the use of medical cannabis or not. Virginia falls into the other group of states whose law is really silent on the matter. For those other states and for Virginia, the courts will end up answering the question, and the courts that have addressed it in other states have reached different outcomes based on different factors. So just by way of example, California and Colorado courts hold that employers have no duty to accommodate, while Massachusetts, for example, holds the opposite. So because the new Virginia law is silent and the existing laws are silent in Virginia, we are carefully evaluating cases that may present this question to the Virginia courts, and we're advising clients accordingly. I think we can, however, be relatively certain of two things. First, Virginia employers will not be required to tolerate impairment at work, which is something we'll talk about here in a minute, and employers will not be required to tolerate possession at work. Now, there is one exception to the uncertainty about accommodating medical marijuana. Under a law that takes effect in 3 weeks, on July 1st, employers are going to be required to accommodate the use of prescription cannabis oil. Now, the term cannabis oil has a technical definition under the law, but for shorthand, it would include most CBD and THCA oils that have a low delta-9 THC content, which is the most prominent psychoactive ingredient that people think about. So the quick takeaway with respect to cannabis oil is that if an employee requests an accommodation to use cannabis oil, employers should view that request very differently than a request to use marijuana more generally. And we're going to be paying close attention to the cases that come out presenting this particular issue to the courts. Now, so far I've been talking about medical marijuana. As Stan mentioned, in 3 weeks, recreational cannabis use will be legal under Virginia law. So then the next big question arises. Are employers required to allow employees to use recreational marijuana off-duty? And the short answer is probably not. Virginia is an at-will employment state, and the new law does not affect that. Employers may continue to test for marijuana and enforce zero-tolerance policies for recreational marijuana use. Now, if that were to change in the future, Virginia would be joining only 4 other jurisdictions that would require accommodating off-duty recreational use, and that would certainly be a sea change in the law that would come through either new legislation or some court case that has not yet been progressing through the courts. So with respect to recreational use, I think that employers can continue on the same path that they have generally been proceeding. So the subject of drug testing really brings us to one of the more popular topics employers are addressing right now. Employers typically drug test employees because they want to find out if the employee is impaired while they're at work. The difficulty with this is that marijuana metabolizes in the body differently than most other drugs. The length of impairment in some situations is a lot like alcohol. It depends on a variety of factors like the individual's body type, their experience using the drug, their diet, etc. But recent studies show that people are impaired by marijuana for about 5 hours if they smoke it, and for up to 10 hours after ingesting edibles. But unlike alcohol and most other drugs, traditional drug tests can detect marijuana use many weeks or months after consumption. So employers who test for the presence of THC are not actually testing for impairment. These and other issues have resulted in employers questioning whether it continues to make sense to use traditional drug tests to test for marijuana. Now, I know it made the news a few weeks ago, and maybe you all may have seen it. I think it was earlier this month that Amazon announced that they were going to stop testing its employees for marijuana, except in certain circumstances. And Amazon's announcement is really consistent with the question that many other employers have been asking. So the question is, what should an employer do? Well, the shortcomings of traditional marijuana tests have resulted in a few solutions that are available to employers. There are a few tech-based solutions that claim to test for general impairment, but not marijuana impairment specifically. And you can do an internet search for impairment tests, and these will pop up. Products like Druid app and Alert Meter are probably on the first page of a Google search. these measure an employee's cognitive impairment really from any source, be it distraction or drug use, sleepiness, stress, or other factors. Another interesting product coming to market is Hound Labs, a THC breathalyzer. It's the first THC breathalyzer that I'm aware of that's going to be coming onto the market. And the device is similar to an alcohol breathalyzer in the sense of how it's used, but it only tests for recent marijuana use, detecting use only within the last 1 to 3 hours. The device does not detect impairment, only very recent marijuana use. So if this product is something that would interest you, I recommend you Google Hound Labs for more information about the products that they offer. I know employers are really clamoring for solutions to this marijuana testing problem, and you may find products like these worth reviewing. From a legal perspective, I think what's really important is figuring out how to integrate these types of products or solutions into your drug testing policies, which is something that McGuire-Woods labor and employment attorneys are used to helping employers do. So feel free, if this is something you're interested in, reaching out. And the last big topic I wanted to discuss is background checks. Virginia, like many other states, as many of the employers on this webinar are likely aware, Virginia restricts what employers may ask on job applications related to marijuana arrests and convictions, particularly related to those that have been sealed or expunged as a result of the laws that Stan talked about earlier. This slide offers kind of a high-level summary of the recent changes in the law, but let me just offer kind of the main takeaway here. Now is a good time to review your application and interview process. If you haven't reviewed and updated the process that your company uses, and I would say the last 12 to 24 months, I recommend that now is a great time to do so. Reach out and we can help. Okay, that is the quick update on Virginia employment laws. I certainly look forward to hearing from you if you have any questions about how we can help your company. I see there are a few questions in the Q&A, and we'll either address those toward the end of today's presentation, assuming there is remaining time, or otherwise I'll be happy to respond to folks individually. Kate, I will turn it over to you. Thanks, everybody.
Great, thank you very much. And I am going to take just a couple of minutes and talk about banks and financial institutions. If you're involved in any way touching a business with marijuana, whether it's directly because you're involved in the business, or even indirectly because you're providing power, water, internet, packaging, anything, these things can raise potential issues with your bank. So it's important to just be aware of things to be thinking about. And before I get into describing these, I'm going to stop here for just a minute because we've talked a lot about marijuana. John mentioned CBD. Everyone is aware at this point through the 2018 Farm Bill that hemp became federally legal. And that can get fairly confusing. So this slide really just presents that, marijuana and hemp, they all come from the same cannabis plant. So it looks the same, it can smell the same, but it is definitely very different. Hemp is a derivative. It contains no more than 0.3% THC, so the psychoactive ingredient that you find in marijuana. Marijuana is, at this point, still illegal under the Controlled Substance Act. But they're very similar. Both products are regulated by different and sometimes overlapping state and federal agencies. So we've just kind of laid that out here as well. Hemp is the Agricultural Marketing Act. Marijuana is the Controlled Substance Act. However, both of those products can implicate the Federal Food, Drug, and Cosmetic Act. You can also have the Federal Trade Commission come in here. So there's a lot of complicated pieces. And then this does not address CBD. Where does that come in? And that actually tends to be a little bit more complicated as well, because you can have hemp-derived CBD, which can be derived from a legal hemp plant. However, from the FDA's perspective, unless you are dealing with very specific parts of the hemp plant, and CBD is not one of them, you cannot put that into any food, dietary supplement. FDA has started to go after creams and other products recently as well. So while hemp may be legal, it doesn't make the CBD that you see on the corner market or in your drugstore a completely legal product. You can also have CBD that is derived from the marijuana plant. So this, you may have people who are getting a THC and CBD derived product either from a recreational dispensary or a medical dispensary. And so the CBD tends to be a little bit tougher to distinguish, but just wanted to make the point that you can find CBD from both the marijuana plant and the hemp plant, and there's definitely differences to be thinking about. So next, I'll just briefly talk about some of the banking issues that can come up. As we mentioned, marijuana is federally illegal under the Controlled Substance Act. Banks are not required to provide financial services to anyone in or touching the cannabis industry. If a bank does do this, there's very, very strict diligence and compliance requirements that must be met. The financial institution in particular has to have policies and procedures to prevent and detect money laundering. This is basically, to put it very simply, making sure that there's no proceeds that are being used for illegal activity. Proceeds from any product that is illegal under the Controlled Substance Act, including marijuana, falls into this bucket. This also applies to direct and indirect marijuana businesses. Direct businesses, very easy to figure out. Indirect businesses are all kinds of service providers that provide services to these types of businesses. So again, it could be the power supplier, the water supplier, the internet supplier, someone providing packaging. Most bigger banks have policies and procedures where they have got to do some extra diligence on both those direct and indirect businesses. The key takeaway here is if you're going to be involved in any type of business and you have a banking relationship, it's better to approach your bank and be upfront and talk about what's happening, see what the bank's policies are. And then FinCEN and the National Credit Union have issued guidance to banks that they can follow when they're dealing with businesses in this space. FinCEN has issued information on the different types of banks and credit unions that are providing services to these types of businesses. It's on the FinCEN website. I apologize, it's a little bit difficult to read, but we just included an example here of one of those. And we could do a whole webinar on banking, but those are some of the key items that you need to be aware of. And then in addition to the federal issues, at this point, because we still have the federal and state conflict between marijuana being illegal at the federal level and legal in some states, some states have tried through state law measures to make banking easier for businesses. These are just examples of different things in California, Illinois, and Nevada, which has made things a little bit easier. We have found there are several banks that specialize in dealing with businesses in the cannabis space. They're generally smaller banks. They are easy to find out there. But at this point, until we get a little bit more clarity, it can be difficult to find banking relationships when you're dealing in this space. And Ryan is going to talk a little bit later about some of the bills that are in Congress to try to address some of these issues and hopefully get everybody relief. But that is just a brief overview of banking things to think about when you're in the marijuana space. And with that, I will turn it over to Matt, who is going to address insurance considerations.
Good afternoon. So I have found in the last few years that my practice has increasingly migrated towards almost exclusively dealing with insurance recovery. So with this big change coming in the law here in Virginia, wanted to think a little bit about what bearing that's going to have on insurance contracts and insurance recovery in particular. The big problem we have, of course, right, if someone comes to us and says, well, hey, am I going to be able to get insurance for this aspect of my business, which is affected by marijuana legalization? Well, we don't know, right? We don't have any Virginia decisions. We don't have any Fourth Circuit federal decisions. So we're going to try to kind of read the tea leaves a little bit based upon a couple of reported cases that I'll talk about at the end. And first thing I'm going to do is sort of step through some common policy types that we see in the business environment and try to identify some of the issues we have there. I'll probably circle back just briefly to this at the end, but whenever you're buying insurance, the thing to think about, of course, is what are the risks you're worried about, and make sure the policy covers them. And when in doubt, try to get an endorsement to make it clear, because that will greatly help you on the back end if you have a claim and the company doesn't want to pay it. So I want to talk briefly about three very common business policy types: CGL, directors and officers, and commercial property. And try to identify some issues on each one. CGL, commercial general liability insurance, is of course very common. Almost all businesses have this in some form. It provides coverage for injuries to third parties arising out of the business's operations or defective products. Generally, the insurance company has a duty to defend you against claims that are brought against you by those third parties. They've got to hire a lawyer. They've got to defend you and then also pay any judgment entered against you up to the policy limits. And there's some different styles of those policies based upon whether they cover things that, the injury actually happens during the policy period or whether you're notified during the policy period. And that works a little differently. But either way, that's the basic idea of CGL. In the context of marijuana legalization, some things to look out for is that many of these policies have an exclusion for exposures to carcinogens. And you can see how this is, developed over time based upon, asbestos claims, and people that, 50 years later are still going after insurance for exposure to asbestos. So most policies now exclude any kind of exposure to a carcinogen. Exclusions for criminal acts are very common. Your CGL policy is probably not going to pay if you or one of your employees does something overtly criminal. Generally, and this is going to be a big issue in our discussion of insurance today, most courts will not enforce any contract, whether it's an insurance contract or some other kind, that violates public policy as enunciated by the legislature. So a carrier is going to be able to step in and say, hey, I don't want to have to pay this claim because to do so would violate public policy. And again, I'm going to talk a little bit about that here in a minute in the context of some reported decisions we have from some courts. Another risk to think about in trying to recover is almost every CGL policy has an exclusion. All right. I apologize for the intermission there with some nice hold music, but we'll just try to pick back up. In the context of commercial general liability, we were talking about some of the potential, coverage issues that can come up, and one of those was the expected or intended exclusion. Here's an example from a very common coverage form. This insurance does not apply to bodily injury or property damage expected or intended from the standpoint of the insured. So to the extent someone is engaging in a business or conducting business activity that involves a known carcinogen or something that can cause health problems, it is certainly possible that the carrier could assert that the injury was expected or intended. Similarly, here's an example of an exclusion for criminal acts, personal and advertising injury arising out of a criminal act committed by or as a direction of the insured. So given that marijuana remains illegal under federal law, it's going to be fairly simple for a carrier to step in and say, hey, this is a criminal act and is therefore excluded. On directors and officers liability insurance, this is coverage that's purchased to protect directors and executives of the company from lawsuits brought against them based upon their business activities. Typically, it will provide, if not a defense, at least reimbursement for defense expenses. Often you get to choose and hire your own lawyer depending upon the policy. But it will also typically exclude criminal acts. This is not a situation where you're going to have a consumer of a business bringing a suit that's covered under D&O, but it's certainly possible that you can have shareholder derivative actions, government enforcement actions, those kinds of things, where a D&O policy would respond. And if so, it's going to sort of raise the question of whether there's coverage. I've given you an example here from a D&O policy I had in my files. It says this policy shall not cover any loss in connection with any claim arising out of, based upon, or attributable to any deliberate fraudulent act or significantly any willful violation of law. So again, all this stuff is an issue because marijuana remains illegal under federal law. The third and final type of policy I want to talk about just briefly, and most relevantly probably, is commercial property insurance. If you have a business, you almost certainly have commercial property insurance. The basic idea is that it provides coverage if your premises or property is damaged. The coverage trigger is physical loss or damage. Classic example would be something like a fire. Typically, it'll pay to rebuild the building, to pay for any lost inventory or business property, and also provide replacement business income up to a limit while you're getting it rebuilt and fixed. So thinking about how that affects marijuana, there are common exclusions for growing crops, contraband, and again, it's going to be, your carriers are going to argue that it's contraband under federal law. And then finally, as mentioned before, public policy. So here's an example from a common coverage form. Covered property does not include contraband or property in the course of illegal transportation or trade. It also doesn't include land, including land on which property is located, water, or growing crops. So both growing crops and contraband are excluded from this commercial property policy that I pulled this out of. So I'm going to finish by talking about two cases that we have where courts are construing insurance policies in the marijuana context. And the first one is from 2012 from the U.S. District Court in Hawaii. And the facts here in this Tracy against USAA casualty, we had the plaintiff who had a card, was registered to use medical marijuana under Hawaii law, and somebody stole 12 marijuana plants from her home, so she made a claim against her homeowner's policy. And interestingly, USAA initially tried to negotiate with her and seemed like they were willing to pay something, but they weren't willing to pay what she deemed enough. So she sued them in federal court in Hawaii, and the court ultimately granted summary judgment to the insurance company. The court found that the property was covered, but they bought the argument that to pay her would violate public policy because federal public policy, as specifically enunciated by Congress in the Controlled Substances Act, made marijuana illegal, and therefore the court declined to enforce the contract, and she didn't get paid. That case did not make it to the Ninth Circuit because the appeal was filed too late. But that's a case from 2012 in the District of Hawaii. And here's what the court said. This court cannot enforce the provision because plaintiff's possession and cultivation of marijuana, even for state-authorized medical use, clearly violates federal law. To require a defendant to pay insurance proceeds for the replacement of medical marijuana plants would be contrary to federal law and public policy. But things have changed. I was in Michigan a few weeks ago, and I took this picture out of the windshield of my rental car. This is a billboard that's up on the highway in Michigan where these folks are offering to deliver cannabis products to your home with a minimum order of $20. And this is a picture of a grow operation, perhaps similar to the one we're about to talk about. In 2016, the U.S. District Court in the District of Colorado decided the Green Earth Wellness Center, LLC, against Attain Specialty Insurance Company. And what happened here was you had a medical marijuana dispensary who sued the carrier that wouldn't pay its claim. The dispensary had experienced smoke damage to both growing plants and finished inventory at its business premises from a wildfire, and the carrier didn't want to pay. So the court first found and enforced the exclusion for growing crops, like the one we looked at a few minutes ago. It held that the potted plants inside the building were growing crops. They didn't have to be in a field. Being in a pot was good enough, and therefore they weren't covered. However, the court rejected the carrier's attempt to enforce the contraband exclusion to not have to pay for the inventory. The court found that the exclusion was rendered ambiguous because federal public policy was ambiguous, and it wasn't entirely clear whether it was illegal or not, because the statement the DOJ made about whether or not it was going to enforce the law. And so here's what the court wrote. The nominal federal prohibition against possession of marijuana conceals a far more nuanced and perhaps even erratic expression of federal public policy. The court will not attempt to explain or summarize the conflicting signals that the federal government has given regarding marijuana regulation and enforcement since 2008. In short, the policy's contraband exclusion is rendered ambiguous by the difference between the federal government's de jure and de facto public policies regarding state-regulated medical marijuana. And then the court goes on, and this is significant, I think, and this may be what the case really turned on, was the insurance application that the insured filled out for the carrier included a supplemental section that was specifically designed for marijuana dispensaries. So they had supplemental marijuana dispensary applications. So there was no question that the carrier knew that they were insuring a marijuana, grow and sales operation. It is undisputed that before entering into the contract of insurance, Attain knew that Green Earth was operating a medical marijuana business. It is also undisputed that Attain knew, or very well should have known, that federal law nominally prohibited such a business. Notwithstanding that knowledge, Attain nevertheless elected to issue a policy to Green Earth, and that policy unambiguously extended coverage for Green Earth's inventory of saleable marijuana. So the court seems to have been influenced by the equities of the situation, that the carrier knew what they were insuring. They couldn't therefore get out of it later by claiming a public policy exclusion. So the other thing, of course, is you've got 4 years between those two cases, big changes in announced federal public policy, if not changes in the actual statutory law. So best practice coming out of that, if your business is going to have any kind of touch on marijuana one way or the other, and you're worried about your insurance, I would be very clear and explicit with the carrier and insist that the policy really spell it out in terms of whether it's going to be covered or not. And I would come back to the point I made earlier, that these arguments about public policy and enforceability of contracts apply not just to insurance contracts, but really any contract that would involve the nascent marijuana industry and whether it's going to be enforceable. So on that note, I will hand it over to Ryan Bernstein. Thanks.
Thank you very much. That was an excellent overview. And one of the things I would highlight is what you said, public policy is in flux on the insurance side, and I think that is very much true on the federal side. I joined, kind of brief background about me, I joined McGuire Woods a few years ago from Senator John Hoeven's office. At the time, he was the chairman of the FDA Appropriations Committee, which we dealt a lot with CBD, some of those issues that were raised earlier by Kate, and pulled me over to continue to work on a lot of these issues here at McGuire Woods. So I just wanted to kind of give a highlight of some of the broad-based bills that are really driving the conversation out here in Washington, D.C., and frankly have a lot of implications about what the panelists have said today from our team on what's happening on the state side. The one really to talk about initially is the Secure and Fair Enforcement Banking Act, known generally as the Safe Banking Act. This is the one piece of legislation, I would say, that has the most bipartisan support of any marijuana-related bill in Congress. This bill, frankly, has already passed the House of Representatives this year on a very strong vote, 321 to 101. And I think, frankly, this bill would have passed Congress last year if it didn't happen to have, if we didn't happen to have Senator Crapo from Idaho as then the banking chairman. He is probably the most conservative member in the Senate on this issue, and he supported the policy but wanted to address the larger implications of marijuana use in this bill, and frankly, it never made it out of his committee because they never addressed any of those issues he raised. So this year, Crapo is no longer the Senate banking chair, and it is Senator Brown, who is a supporter of, frankly, legalizing marijuana and of this bill. So in theory, this bill should have a very good chance of getting through Congress. But as we kind of will walk through here, there's a lot of things that get pulled into this discussion that are beyond trying to fix certain policy issues like banking. Banking is one of the big things that everybody agrees on. But because it is so popular out here, public policy is not the only thing in flux. It is the process of passing these bills. So Senator Brown, even though he supports the Secure and Fair Enforcement Banking Act, he wants to add some sentencing reforms to the bill as it moves forward. So it might get weighed down moving forward, which will make it more difficult to pass. And we just want to show a couple of examples of that. Another bill that is a little bit broader, of course, than the Safe Banking Act is the States Act. This bill, I think, has a lot of support, frankly, from the administration. President Biden has been pretty cautious generally on this for his party, and he kind of supports more of this federal approach where it allows states, territories, and federally recognized tribes to determine their own marijuana policies within their borders. So this has been something that the administration's kind of been supportive of. But the question is, does this go far enough for Congress at this point? And I just say a little side note, there's been a little controversy within the administration that several employees or several applicants to federal positions have tested positive for marijuana when they went in for their interview and application. And so far, the Biden administration's taken a pretty hard stance on that and not hired several of those individuals that have tested positive for marijuana use. So they have kind of not taken a more expansive view of hiring when it comes to individuals that are testing. So that kind of shows you where the administration is. Well, where is Congress going to be? Well, I'd say a broader bill that is more likely where the majority of at least the Democrats are now is the MORE Act. Frankly, this bill passed Congress late last year in December 2020. It was quite a statement. It was the first comprehensive marijuana bill to pass Congress, and they did it right at the end of the year. Now, this was just reintroduced again by Jerry Nadler from New York, the chairman of the Judiciary Committee, and he's working to try and pass it again this year. But, well, I want to highlight a couple things that it does. This is more expansive, so it would remove cannabis from the Controlled Substance Act, eliminate criminal penalties under federal law, and even gets into taxing, where it would tax cannabis products and prohibit the denial of federal benefits based on marijuana use. So this is more expansive even than the States Act. But the question is that what is going to pass Congress? Well, Schumer has really stepped up on the Senate side and said, look, if we're going to pass a marijuana bill, I want to make sure it's comprehensive. And this is what maybe implicates the Senate Safe Banking Act. Schumer wants something very expansive, and he's working with Senator Booker and Senator Wyden to come up with a bill that they keep saying we will see soon, even though they've been saying that for a couple months at this point. What they said is, look, we want to make sure that we have restorative justice, we protect health, and we tax the marijuana, and that we get a good buy-in from all the stakeholders that we have the right legislation moving forward. What will this actually look like? Well, it probably will look like pieces from a lot of bills that are scattered out amongst Congress at this point. Obviously, removing marijuana from the controlled substance list, eliminate criminal penalties, establishing a national tax and regulatory framework, and expunge convictions for people that have been convicted of marijuana offenses in the past. Now, there's a lot of other things, too, that are out there. One of the things I know is somewhat of interest here is, well, what is the Gun Control Act of 1968? What does that do? Is that implicated here? Because there's a circuit court decision on that saying, look, the federal government still bans the sale of marijuana, or guns to marijuana users. So there's a bill in Congress to fix that called to protect the Second Amendment right of adults whose use of marijuana is permitted by state and tribal law. Probably the longest bill name in Congress at this point. But there's something kind of everywhere out there about trying to make sure that all the pieces get cleaned up before we pass probably a one and done marijuana bill at this point, because I think the Democrats see this as really their biggest and best chance to get marijuana policy done right from their perspective. So that's going to be challenging as you bring on more and more issues into one bill. There's always something in there for somebody. There's always something in there for somebody that to dislike it. So that's why it's very challenging. For that reason, I think on the federal side, we're looking at probably, if something's going to happen, not having it happen until probably the end of this legislative year. I don't see this passing as a standalone bill. It would likely have to be included in a larger must-pass bill, probably like the year-end government funding bill. If it doesn't happen there, I guess we'd probably have to look into, I would guess, the summer of 2022. So there's some small windows here for the Democrats in Congress to pass some of this broad sweeping language. So it is somewhat unfortunate that there are some parts of marijuana policy that could make it through Congress as a standalone, but before Congress is willing to do that, they want to see how much of basically the cake they can get and eat it and pass it into federal law. So we're watching that on our side. A lot of things obviously reach back into the state and frankly into companies' actions, whatever the federal government takes. So we'll be watching that very closely in the next several months. So with that, I'll turn it back over to Kate with a few more minutes to go.
Great. Thank you very much, Ryan. So I think we have a couple minutes left for questions, which we'll try to answer a few here. We have had a few people ask about the slides. Those will be emailed to you if you registered for the webinar. We will also be making them available on the McGuire Woods webpage. If you go to the events tab, they will be there as well. So yes, they will be available. And I think to sum it up, I mean, the really unique thing about just cannabis and marijuana in general is it really, really does touch on pretty much every aspect of business, from employees to banking, to insurance, to contracts. I mean, it's very expansive and a lot of different areas to think about. One question I will answer real quickly. I did see a couple people put up one that CBD oil can result in a positive THC drug test, which I can start with, and John, maybe you can jump in on. Someone also asked a similar question about physicians kind of recommending OTC CBD oil to chronic pain patients. From the regulatory perspective, the over-the-counter CBD oils, supplements, food, anything you see, right now there's no specific regulatory requirements for those. So anything that comes under the Food, Drug, and Cosmetic Act, there are specific limits on dietary ingredients and everything else. there is nothing at this point for CBD. And if you look on the FDA's website, they took a whole bunch of products and tested them, different types of things with CBD, and you will see the range of CBD in those products varies widely. And that is because there is no standard. In Virginia, on the medical side, and soon to be on the adult use side, it is actually more regulated through the states. If a product has a specific amount of CBD and or THC, there's guidelines for that. The dispensaries are extremely regulated. They are constantly having to provide laboratory test results. So it's actually a more regulated, and you know what you get on both the medical and the dispensary side. And John, I don't know if you want to jump in on some of the employer sides of that as well.
Yeah, I will just chime in and say that employees who are using CBD oil, whether it's because their physician has recommended it or for some other reason, sometimes they're coming away from a drug test quite surprised that they're testing positive for THC, a different chemical compound that can find its way into CBD oils depending on the quality control of the CBD manufacturer. In most circumstances, at least certainly in states that do not have broad medical protections for THC users, and for employees who drive commercial vehicles, so they're regulated by the U.S. Department of Transportation or the Federal Aviation Administration's drug testing requirements, they're finding that it's not a defense to say, but I was only using CBD. The fact of the matter is that if there's sufficient THC that has found its way into the CBD oil that renders the drug test positive for THC, in many circumstances, that is not going to be a defense. And I'll take this time now to respond to another question. I had a slide on this, but I didn't discuss in great detail. For those employers that do have employees regulated by the U.S. Department of Transportation, for example, commercial driver's license holders or employers regulated by the Federal Aviation Administration, or employers regulated by a federal contract or federal grant pertaining to drug testing or drug use, you are still going to be expected to adhere to those federal laws and federal expectations, even under the new state law in Virginia. But CBD is one of those where some employers are finding that it is advisable to inform people in their drug testing policy, if you use CBD oil, you may still fail a drug test, and it will not be a defense to a positive drug test, bearing in mind the new Virginia law that does require you to accommodate cannabis oil. So lots to think about, and it's a pitfall that a lot of folks are falling into.
And we are up on our time. I will just add on one more thing to that, just from the federal contracting perspective. If you're involved in federal contracts, that's a whole nother ball of wax. It's almost its own separate section, because I think, as someone may have asked in the questions, I mean, there are specific certifications and other things that you are supposed to be making, in addition to, John, like you mentioned, the whole, drugs in the workplace or drug-free workplace. We have members, in addition to John and his team, we have members of our team who specialize also in federal contracting and are very familiar with the cannabis issues that come up. So if you have follow-up questions on that, we do have some team members as well that can help with it. And I'll just remind everybody that more information about our practice in general is on our website. But with that, we thank everybody very much for your attention this afternoon. We hope this has been informative and helpful, and I hope you all have a terrific afternoon. Thank you very much.